one more picture that we did back in yesterday. I found three. I don't know if we gave it to him, but I found three of one picture here.
This is an action entitled State of Ohio Plaintiff versus George Washington Wagner, the fourth, case number 2018, CR 155. Today is Friday the 4th of November, 2022. The defendant is present in court with his attorneys, John Parker and Richard Nash, and the state of Ohio is represented today by special prosecuting attorneys Angela Canepa and Andrew Wilson. Also present is Ryan Scheider of the Ohio BCI&I. We have convened here in the absence of the jurors to consider certain evidentiary matters. First of all, the court notes that prosecuting attorney Rob Junk is not present. It was reported that he is ill this morning and unable to attend. In the court's view, that would constitute sufficient reason to postpone the hearing if one of the prosecution's team is unavailable due to illness. However, that hasn't been requested, I don't think. I'm not sure whether both sides wish to proceed without Mr. Junk. But I would hear from each of you. If everybody agrees to proceed without him, then we can do that. Otherwise, we probably would not do that. I probably would continue. So what's counsel's feeling on that?
Yeah, Your Honor, Mr. Junk did contact all three of us here at the council table. He did indicate that he was ill and that his wish was that we proceed without him. I do have some reservations just because he is obviously counsel, but you know, his request is...
Well, it's up to the people standing here, I guess, whether they're requesting a continuance. I've sort of tipped my hand there. I'm willing to grant a continuance of the hearing today, a postponement of the hearing today. Basically, just we have the jury coming in, but we can reschedule for Monday if the state wishes to. do the same, of course, for defense counsel too. I don't want to require either side to go forward without their full array of legal talent, so.
Yeah.
I was just deciding if you feel well.
Ms. Kneppa and I have talked about that a little bit this morning, and we're okay with moving forward. One of the issues that we discussed, and Ms. Kneppa raised, was we're just nervous about any inferences the jury may draw by the fact that the county prosecutor's not at the table with us, or any thoughts that they may have on that. I don't know if that's cured with an instruction that just says Mr. Junk is unavailable today, and the parties have decided to proceed without him. He's expected to be back Monday. I don't know if even that's something that the defense would want to do. That's our only concern. We are ready to go ahead and proceed forward today with that one caveat.
I can't, I guess would be as good as mine about what a jury would think about it, but I certainly can just indicate that he's unavailable. I probably would say due to illness, but that would be the end of that. That would be all I would say about it, but how that affects the jury, I don't know. What's defense counsel?
We take no position. Whatever the prosecution wants, whatever the court rules, we're fine with.
Judge, I mean, just to be clear, the jury's not due here for another half hour or so.
Right,
And we've been scheduled to discuss a couple of legal issues.
right.
I don't know if the state prosecutor, the special prosecutors that are here want to go forward on the legal issues only, or just put everything on hold, or proceed on the legal issues and not with the jury. I'm not sure exactly what the position is on that. With respect to the legal issues, just to make the record clear, at about 8:10 this morning when I walked in, I did receive a large stack of intercepts, transcripts that are meant to be part of this legal hearing. Had a chance to review some of them with my client, certainly not all of them.
Yeah, one concern the court has is that we have, and I guess we're sort of sidestepping a little bit here on Mr. Junk's presence or not, but just let me mention that we have, I don't know how many transcripts it is. Is it 18? Did somebody mention the number?
There was 21 initially turned over to the defense. I've given them 3 more, and there's a couple more.
Okay, so we have a couple of dozen at least transcripts, which I understand, or documents, which I understand to be transcripts or alleged transcripts of snippets of recorded conversations. First of all, let me say, I thought that those kinds of things were going to be done and turned over prior to trial. I mean, maybe I misunderstood, but I remember it coming up, and we've had several of these prosecutions, so I won't specifically say it was in this case, but I know that it was requested, especially concerning.
Your Honor, we did turn that over, just so to be clear. We turned over transcripts for both the 2017 and the 2018 T3s. Today is concerning just the 2018, and this is a subset of that. But they have these transcripts.
Oh, all right.
It's just we're now identifying the ones that we intend to use. Now, in fairness, I mean the 2018 T3 especially, I don't remember how many pages it is. A lot. But, so, we are.
I mean, just to follow up, I can go back.
Nope.
I mean, yeah, we were given the original recordings, which are probably hundreds of hours, dozens of hours of recordings, and we did get a transcript, but none have ever been identified as to which ones they want to use. And of course, how long have we been in trial? 2 months, 3 months now we've been in trial, and of course, the ones they want to use have to be considered in the context of what has been presented in court so far. So while we're familiar in general with these transcripts, putting them in context of what we've learned through other witnesses is obviously important.
I think Mr. Parker makes a pretty good point. Early on, that's one of the reasons we didn't necessarily identify specific recordings. We gave them everything and said, hey, we may use any of these because, you know, it may change as the trial goes on, which ones we're actually going to use. We didn't want to put ourselves, again, in a trick bag where we didn't identify a specific one that, as the trial went on, oh, now we need to present this one, and then be stuck with, well, you didn't identify that one. So we gave them everything, and again, literally, a lot of times we don't know until just before the actual ones we're going to use. So we've identified those, we've handed those over, and one of the arguments that we like to make with respect to these transcripts is their use as a listening team. That's part of the argument that we are prepared to make. We've got case law support this morning. But with each of these transcripts, there is a recording that we would play in court.
Well, let's say 24 right now, maybe 25 transcripts, snippets. Some of the transcripts, and I'll be frank with you, I tried to, counsel gave me a copy a few minutes ago too, and I've been going through them as quickly as I'm capable of reading, which is not maybe the fastest reader. I noticed that, at least in the case of one, there was sort of an introductory paragraph that wasn't really a transcript, and it was, this is this, and I noticed in a couple of others, I think, that there was meaning this in parentheses, and those kinds of things are things that we've been trying to stay away from. Is saying that when somebody says him, meaning this person or meaning this, because that's interpreting what's being said. Now there may be more of that. I'm only saying that I saw that in one or two, but there may be more of that. There were a couple of the transcripts that I was looking at where I would say that the balance between the probative value versus the what's the correct term, the harm to be caused might be questionable. Now that's not true in all of them. There were some in which there was a discussion primarily of hiring an attorney. Maybe some probative value somewhere in there, but it looked like mainly it was who we're going to get as our attorney and so forth, which is something else that the court questions about whether. So I guess what I'm trying to say is, just as a general matter, is it looks like that some arguments that might apply to some of the transcripts wouldn't apply to other of the transcripts. So it's going to be for the court just to say right now, all these transcripts are okay or all these transcripts are not okay, wouldn't be the right way to deal with it. I don't think. I think it's going to be a matter by matter. So I'm not sure there's time this morning for defense counsel to analyze all those from that standpoint and make arguments, or quite frankly, for the court to look at all of them in relationship to the argument. So that might be another reason not to proceed with these today. But
so that actually maybe circles back to the Mr. Junk, since we don't have Mr. Junk here. And we have Ryan Scheider as a witness that we put on who wouldn't get into these transcripts. So we could do that if the court wanted to. We have the jury come in at 10 o'clock. I hate to bring them in for an hour and then have them go while we try to decide what we're going to do with this stuff. Another option would be to call the jury off and basically handle our arguments with respect to these transcripts in the attached recordings. And we can do that without Mr. Junk's presence. And then Monday, Tuesday, we're gonna allow them to open their case on Monday. But when we go back into our case, again, it would be cleaner and some of these issues would be addressed. Again, one of the arguments we're going to make is the use of these transcripts for a listening aid. And if there's any concerns with parts of those transcripts that we don't want in there, that would give us some time to remove those subject to any court ruling on that. Again, we do believe the law would support when the quality of the recordings is poor, we believe law supports allowing the jury to use a listening aid, subject to any redactions or cleaning up that the court would order us to. So that's an option as well. We could take the whole day to clean this up. We could put a witness on and then take the rest of the day off. However the court wants to proceed, we can certainly do that.
Was this the only evidentiary arguments we were going to have today that concerned
No.
these?
No.
There's one other.
The one regarding, and that will come up with Special Agent Scheider, Your Honor, is regarding the truck photos. If you'll recall, Your Honor, we had provided defense and the court ultimately with some photographs of the back of that vehicle that was reportedly used the night of the homicides. And we had designed or built the false bed according to the way that Jake described it when he was on the stand. I had a recollection that he said vertical and that, you know, I was doing this with my hands straight up. It's impossible for me to describe what that looks like. But lay my hands flat in the air to describe horizontal and then on their sides to describe vertical. And we did go back and get the transcript, Your Honor, and it does very clearly say, he says that he did a 2x4 on top of the that, which was the eyelets that he described, and then screwed the plywood into it. Can you tell us if the 2x4 was, and he said vertical? I said it was vertical, and he said it was vertical, 4 being vertical, 2 being down. And then you said you screwed the plywood into that on the top side. Yes, on the top side. And I said to make a larger compartment in the bed for you and your brother. And he said the addition of the 2x4, and I said yes. And he said no, the vertical was more for integrity, for weight. And I asked if that was sturdier, more reliable. So I feel like he did describe that in the manner that we have built it. And the court had expressed a couple of concerns because we also had some volunteers to get in the back of the bed, and again, just to kind of rebut the inference that has been made thus far that the weight, because of George's weight, he would not have been able to fit into the back of that bed that night. And so we had 2 individuals, but they had masks on, not to, in any attempt to recreate the night, you know, where Jake testified that they both wore masks. It was solely because they were undercover, and I think they were police masks, you know, it said police on it. But regardless, the court expressed trepidation about that because you didn't want it to appear to the jury that we were trying to recreate that night. And additionally, they had put screws in the side, and that was not testified to, and we've got no reason to believe there was ever screws in the side. The court asked if there were holes. At the time, I didn't know, and frankly, I didn't even look, but we just simply removed those screws. So it is now constructed in the way exactly as how Jake Wagner described it, and we had one of the same volunteers, but a new volunteer, and we took their weight and height, and they got in the back of the truck without masks on. So our request will be that we be permitted to use that. I have photos. We did provide those to counsel yesterday, I think, because we did it in the evening one night this week and gave it to them the following day. So that's our request with that. That would come up with Agent Scheider, so that would need to be decided, you know, if we are going to proceed with.
And the state's position is to, on that issue at least, that you wish to proceed today without Mr. Junk to argue that point. Is that correct?
To argue that point, yes.
And the defense, as far as proceeding today on that issue without Mr. Junk here?
That's their choice, Judge.
Okay.
We do have some things to say about the photos.
Say it again.
We do have some arguments
Yes,
about the photos.
about whether they should be allowed or not, but that comes at a later point, I guess.
We would like to address
Your Honor,
that.
would you like to see the photos, or?
Well, it's up to,
We would like to address, whenever the court wants us to make our legal arguments, we're prepared to do so. We'd rather do it before the testimony.
Well, certainly, yeah.
all right. Because it was the idea of having the jury up, I mean, the testimony wasn't to argue about, or was the testimony to argue about the admissibility, or is that what we're doing, that without the jury here? Is that correct? Okay.
Yes, just that we would be able to show it to them.
And you wish to argue before the testimony, or?
Yes.
Okay, all right.
Judge, we were providing, let's put some context into this. Last Friday, as I'm sure the board will remember, Jay finished his testimony. I think he was on the stand all year ago. And so whenever he finished Friday around 4:30 or so, court adjourned, and the prosecution came up and handed Mr. Nash and myself a stack of photos and said, "These are for you." And so that was the original version of this demonstration that we put together. We brought it to the court's attention, I think, Monday morning, and I think there was a consensus that there were problems with the way it was done, and so they have gone back and now redone it, basically, and handed this new stack of photos to us yesterday. So here's our position, Judge. One, Jake never identified this experiment. The initial experiment with the plywood and the 2x4s and this truck, he did describe it during his testimony, but they had these pictures available during his testimony. And they did not have him identified to say, "Jake, is this the way you built the truck?" And they certainly never gave them to us to allow us to cross-examine him about, "Jake, is this the way you built the truck?" And the department. So that's a problem, because they're going off his testimony when he was clearly available to identify it or not. They had it in their possession. They did not give it to us. And now they want to use it as if it's accurately built. And we're simply not going to stipulate that. I don't think the court should accept that. Number two, we learned yesterday more about this truck from Katie Wagner. This truck was recovered last year, what's it, 2021, more than 5 years after the crime, or about 5 years after the crime, I guess. She had made various changes to the truck, including new tires, I believe she said. And so, we don't know if this truck has the same size tires that it had at the time of the crime, if they are smaller, larger, what the ones were at the time of the crime versus the ones depicted in this picture. So that's a potential problem. Jake did testify that he had placed, I believe it was about a dozen bales of hay on top of this piece of plywood that he put on the back of the truck, allegedly. I'm not a farmer, I don't pretend to be one, but I do know that bales of hay weigh a certain amount. And I'm told 40, 50 pounds is not unusual for a bale of hay. And so if there are a dozen or so bales of hay on top of this, it's not depicted in their demonstration. And this piece of plywood is approximately, I don't know how big it is. It fits in the back of the bed, basically 4 by 8 roughly, 4 by 7 or 6. But this isn't an accurate description, considering the absence of any hay whatsoever, and how that would be secured into the truck. Because there is, just looking at this, maybe a 1 or 2 inch lip. And so, these are concerns about all of this. And the timing of it is, Jake literally walked out the back door, was done with a week's worth of testimony, and was never shown this to say, is this the way you did it or not?
Let me ask the state here, was there some reason why, when we had the person here who built or allegedly built the contraption, why he wasn't asked any questions about these photographs?
Well, Your Honor, there was no reason, there was no intent. This testimony that I got was on direct, so it was day 1 of his testimony, not day 4. And, so, again, they had every opportunity to cross-examine him on the way you're describing that, how on earth would it be able to hold up or whatever. We simply built this according to that. And again, this is a we could have done this in our rebuttal case. You know, there's no requirement that we do it in our case in chief. There's an ability to do it. So it was not an intentional thing. And again, I specifically asked how it was built on direct. They had every opportunity to cross-examine on those details, and they did not. And again, I mean, he described that it was either straw or hay. He did not know which. And that's not relevant. I mean, that may go to weight. He can argue that in closing arguments that this, you know, doesn't hold up to, you know, whatever inferences that we're asking the jury to make. But, you know, they have raised this inference of his weight and an inability for him to fit into the back of his vehicle. So we should be permitted to demonstrate that that is, in fact, not correct.
You still are in your case in chief, though. You're not in your rebuttal case.
Yes, we are.
So,
Yes, I mean, we could, I mean, as this court knows, we could wait until they put that. They've got several weight documents that they provided to us, and photographs and stuff that they've been, you know, doing, which is why I wanted to know how he made this, because if he had, you know, put it across underneath the eyelets, just a piece of plywood underneath the eyelets, if he had put the piece of plywood on the eyelets, well, he told us he used a 2x4 and did it vertical, which just gives it more room underneath there. So we felt that that was worth pursuing, you know, which we did. So, you know, they certainly are free to do the same things. So I don't.
Well, I haven't seen the photographs that you intend to introduce. I'm a little curious about, I remember the ones that we looked at on, was it Monday or whatever day it was, that were with counsel present, and the concern that you indicated the court had expressed because there were masks, and it looked like almost whether there was an intent to do a reenactment, which I was a little bit concerned about. But also, as I recall, there was not just photographs of the constructed thing in the bed with the plyboards and so forth, but there was some indication of shooting positions and all of that.
Oh, you mean underneath the truck?
I'm sorry.
Go ahead, Joe.
Well, no, what I was going to say is there were some people lying under with the rifles and so forth, and counsel here has mentioned that there's new tires and now on the truck and all of that, and I don't see how you could know.
Yeah, Your Honor, first of all, we did not have anyone have a weapon in their hand. Nobody had weapons in their hands when we took the first
Okay,
pictures.
well, they're just laying
But they
there
were
now.
underneath it,
Okay.
again, just to show that there was clearance. We did not do that this time, quite honestly, I think because we forgot. But we did not redo it this time. And so we won't be seeking to do that.
So you're not going to be showing people under the truck, just under, but you are going to be showing people under the plyboard.
Yeah, and I can give the court a copy of what we have if you would like to see it, just so.
Yeah, the sole limited purpose of this evidence is to rebut the inference that the defense has raised that it is impossible for somebody who is as big as this defendant, along with his brother, to get into that truck. So we were very conservative in the way we set this up. You'll see again that the plywood actually dips down below the lip of the truck, and the two individuals that we used are both significantly bigger than this defendant would have been and his brother would have been at the time. So we were very conservative with respect to how we loaded up the truck, solely to rebut the inference that it's impossible for people this size to fit in the back of that truck, close that tailgate up, and have room to go.
Yeah, I mean, another point I forgot to mention earlier is the thinking back on Jake's testimony. I believe his testimony was that he was in the back of his bed for the time it took to drive from Peterson Road over to Union Hill Road, which I think is about 20 minutes or so. And then he was in there some amount of time after he claimed to have driving. And so, you know, the pictures we have with the tailgate down, I don't know if there's a video of them or not, if they were in there for that amount of time.
then, they went out to that place and took photographs of that truck before the trial even ever started. And asked the jury to look at that truck as a jury view. You'll remember that they're the ones that added that truck onto the jury view. So they had as much access, they could have done exactly what we've done. They did not. They stayed away from questions of Jake on this for reasons I can't answer, but their argument right now is raising the very argument that we are seeking to rebut. What he's saying is closing argument stuff. You know, we could certainly have these individuals come in where they said they could write abatement back in there, that it was very comfortable and very easy to get out of and all that stuff. But that's what we're trying to demonstrate.
We requested for months to go out and inspect the truck, because we're entitled to. And that was delayed. We eventually
It's
got out.
never delayed.
It was absolutely delayed. And we eventually got out there with the prosecutors, and we were able to look at the homes that are in the impound area of the county there, along with the truck. So we were able to look at it and take our measurements. That much is true. All right, but that was all well before trial. And so they knew we had an interest in this well before trial.
The other thing-
You didn't raise the weight stuff until trial.
The other thing I would point out is the defendant's identity as being a person who actually went up that hill that night was not put before us until the start of this trial.
That's not true. That's absolutely not true, because our client did a statement in Montana. saying-
Well, so did Jake and Angela and Billy.
So they knew our client's statement in Montana, whenever that was.
Again,
All right, so this is being treated as a motion by the defense for an in limine order precluding this evidence? Is that what?
In essence, yes. I mean, we were, as I described earlier, we were given the initial photos a week ago today. They brought it after court. They brought it to the court's attention Monday morning. And then they've redone the photographs. We were handed it yesterday.
Well, I'm just, procedurally, I was trying to address what we're doing here.
Sure.
It's an in limine order requested by the defense that these not be permitted. So if the court were to overrule that, we still have a situation where we have to lay a foundation for the jury about what you're doing and all of that. And you were going to present testimony today in response to the in limine order? Is that,
Yes.
or in limine motion?
Yes,
Is that
yes.
correct? Okay.
Special Agent Scheider was the one who took the photographs.
And some of that will be repetitious of what would be done in front of the jury if the court overrules the motion, I would assume, correct? I mean, you're
Oh,
gonna
yes.
present-
I mean, you want me to put him on now?
Well, no,
Oh.
So I guess as part of this in limine discussion here, we have a transcript of what
We have the transcript. of
Jacob
the-
Wagner said.
Yes, regarding this, which
Okay.
was in my direct. And obviously, he was subject to cross for at least a day, I think. But, and then we have the photographs, and I would note for the record, then we also have the OLEG of both Jake and George. And I would note that in October of 16, when George had his license renewed, he was 6 feet tall and 252 pounds, according to this document. That was 6 months after the homicides. However, we've been provided documents where he, a year later, or 2 years before, or whatever. But the smallest of the two individuals that we used are bigger than George was, and George is bigger than Jake. So the second individual we chose is bigger than George. And again, Your Honor, I mean, if this was an issue for them, if their argument is going to be George is too heavy to fit into this, too big to fit into the bed of that truck that night, which I'm gathering from their responses that is exactly what they're saying, then we absolutely have a right to rebut that inference. So, you know, I mean, again, they had him on cross. They could have asked him any number of questions about this. And should have.
I just don't understand why the state didn't show him the photograph and say, is
Because
this
we
the way you
didn't
built
have
it?
it.
Is this the way you built it? Because they had the photograph.
We didn't build it until after we asked him, days after we asked him.
He was still on the stand. When you handed
Thursday,
this-
when we had the day off of court, is when we did this.
Exactly, and he was on the stand all day Friday.
It would have gone beyond cross for sure, because you guys didn't touch this.
You didn't try.
You didn't touch this.
He didn't provide this to us.
You had his testimony.
But we didn't have the photographs you had in hand.
I didn't have it when I was questioning him.
Well, it's in your office or in the camera and not yet printed, that you took the photos on Thursday. And he was still on the stand on Friday.
I didn't have there was no,
These guys,
Required it.
whoever took the pictures.
you
had
did not cross him on how that was built.
That's right, because I didn't have these photographs.
Well, you had his words, just like we did.
The words aren't worth much.
I think they are.
Subject to the foundation being laid, I'm not going to grant an order, I'll deny it, an in limine motion to exclude these, but it will, of course, the officer will have to testify. The jury should be given, I think, a cautionary instruction that they're to assign whatever weight to this that they feel is appropriate, and one of the things they may consider is whether this construction is supported by the testimony as they recollected of Jacob Wagner. They find that it is not, they may afford as little weight or no weight at all to this documentary evidence, is what I'm calling this. So now, we will then be calling the jury up. I frankly am going to give you one more shot at this. I don't care. We can have the jury up and go ahead and present this today, or we can call them up and I can indicate to them that Mr. Junk is unavailable due to illness, and therefore we are not having anything presented to the jury today, and bring them back Monday. It doesn't matter to me which way we go with that, but I would require the waiver of both defense and the state before we would proceed today with Mr. Junk absent. And frankly, let me also say to defense counsel here, since you've been presented these things today, that would, in my view, if you wanted the weekend to study them, that would be sufficient too. So it's.
That's actually the position we'd like to take, Your Honor. And I think the state was prepared to argue something about the transcripts. Transcripts are permitted to not to be admitted as evidence, but they're only to be permitted or allowed as a listening aid so long as there's not a disagreement between what the defendant thinks is said and what the state thinks is said. Just like the state didn't know what they were going to use, we didn't either. And so we've just now been given approximately 30 pages or 30 different snippets of transcripts. And the other thing is the rule of completeness. There's about 412 pages of transcripts. So the rule of completeness would allow additional transcripts to be admitted if it puts what the state wants in context. And so I think that additional time, we'd like to have that just to review what we can put here today.
And maybe, if these were numbered or something so that we would have a shorthand way of referring to them whenever we argue about them.
They are.
Okay, all right.
They are.
Your copies are, mine aren't, are they? Or?
Yeah, if you look at the top.
Well, there's a call number, Your Honor.
Oh, okay.
So we haven't attached exhibit numbers to them yet, but there's a call number that identifies
All right.
each one. And
So at least we have something to refer to, because I think that the potential objections differ from one to another.
And some we may not object to, but others we may.
Yeah, and so it gives somebody time to, because, you don't want to miss something on page 3 of an exhibit because you were in a hurry to look at it, so this gives defense counsel some time. I guess that would, in fairness, it would seem to me that would be the best way to look at this. I think allowing, provided that some foundation is laid for these, allowing these is probably the direction the court's going to go. I'm going to overrule the in limine request, but a cautionary instruction will be given to the jury about that the weight to be given to it is theirs to decide, and one of the things they need to consider. is whether the construction here is supported by the testimony given by Jacob Wagner.
Your Honor, the only other thing that I would add with respect to the transcripts as a listening aid, obviously, your concerns with any introductory type commentary at the top of a transcript needs to be addressed. Clearly, we would redact that. There is a case that I would point you to. It's State versus Jones out of the 4th Appellate District here. State versus Jones, it's 2005, Ohio 768, or Ohio Appalachia 745. Again, it's out of Highland County. It's a February 18th, 2005 case where it addresses this issue. And as a matter of fact, in this case, the Court of Appeals says that where the medium used to record a suspect's confession is of such poor quality that a transcript is required as a listening aid, the transcript should be provided. And if the judge is going to do that, the judge should issue an instruction to the jury that obviously the recording is the best evidence, but specifically in this case, the court said exhibit number 22, which is a transcript of the videotape interview of the defendant. I'm instructing you that the transcript is not a complete transcript of the videotape. Further, this transcript is to be used by the jury as an aid in determining the content of the videotape, the videotape interview, if you so desire. So again, if the judge is going to allow transcripts to be used as listening aids, clearly we would support an instruction that lays out that purpose. And then if there is a dispute with respect to whether or not the transcript is accurate, obviously that's an issue that can be raised. I think what I suggest is maybe we pick a couple of the transcripts in the recordings, send them back to the judge so we can do a sampling to see. It is very hard to hear. You'll see that those transcripts are fairly conservative, where it gives a UI in a lot of spots, which means unintelligible. So they were pretty conservative with the way that they did it. So however we want to proceed so that it's smooth when we actually try to go do it. That's what we're...
I mean, if the state thinks they're important enough to use, I think we need to listen to all of them. But I think the way this works is we get them, we look at the transcript that they have, we listen, we determine whether there's an issue. If we feel there's an issue, then we turn that over to the court. So the court is not required to listen to every one of them, but only to resolve any issues that we have in regard to what we see. That's the law regarding listening aids. As far as, and I'm not familiar with the Jones case, but it sounded like whether or not the transcript actually goes to the jury turns on whether or not there's a poor quality of recording. And so, again, we would have to listen to it to determine whether that's an issue. But first, we need to actually listen and see if we agree with what the state is proposing in the listening aid. And if we disagree, then we present that to the court to resolve the issue.
That site was 2005 Ohio 758?
768.
68.
Yes. And again, it's a 4th district out of Highland County, February 18th, 2005.
All right, so the jury will be brought up. There's no reason to let them stay down there too long. I'll just bring them up and indicate to them that the court is ordering postponement of the hearing today. That will be taking up Monday, or canceling the day of today, the jury portion of it today. And I will point out that Mr. Junk is ill. I don't know if that's all I need to say or not. Probably is, and that based on that, the court. I won't indicate who asked for postponement or anything else, but the fact that one side has less than all of their attorneys here will continue. That would seem to be the best way to handle it, if that's acceptable with each side.
Yes, Your Honor.
Yes, Your Honor.
All right. And I don't know if you want me to indicate that there are other evidentiary matters the court needs to consider that do not concern the jury.
I think that would be helpful, Your Honor. I think Mr. Junk is concerned about, he wanted us to go forward and, so he doesn't want whatever. So I think if we also couple it with that there's evidentiary issues.
I don't want to
as
say
well.
anything, it sounds like that somebody, I'm assigning to one side or the other the problem of the jury not being here today. I can indicate that the court needs to consider some evidentiary matters, and also that Mr. Junk is ill, so I'm ordering to continue. So,
Yeah, the only other thing is Monday morning, we're going to allow the defense to call witnesses out of order. So I don't know if we just address that Monday or.
I think so.
Okay.
I think, yeah.
do what?
I think we just deal with it on Monday morning.
Deal with these issues?
No,
no, no.
That-
Mr. Wilson
I
is
see.
bringing up the fact
I
that the
see,
defense is
okay.
going to call witnesses out of order on Monday.
Okay.
I think we can just deal with that on Monday.
Okay, so we'll probably be calling your witnesses out of order on Monday morning, and we'll explain that to the jury that morning. And as far as these evidentiary issues, when does council feel like we can work in an argument about these things?
Well, we intend to work on it all day today.
Okay.
I don't know,
We're going to do it Monday morning at like at 8:30 or something?
well, let's talk about that once we get to jury.
Okay.
Okay.
But, I mean, we intend to work on this all day today.
All right.
See
If
we can
you'll
resolve
be-
these things or not.
If you'll be providing me with something to listen to those with, I can be listening to them today too, although I understand your argument that if it's not a problem, I don't need to consider it, but what else do I have to do today other than listen to tape? So if you provide them, I'll be listening to them. But I do want council to look at, you just about have to read them line for line, because there might be something in the middle there that says meaning this, or if there's any of that, I'm sure that, you know, there may be. I saw, I think, one or two of those in there, and I don't know how many others there are, and that, of course, is something probably that unless both attorneys and both sides agree that explanation should be in there, then it probably should not be.
Yeah, I think, and Your Honor, I should have caught that. I think that only applies to a few of those in
Not
here.
very many, I don't think.
Yeah, and it's at the beginning where it just was like, you know, here's what it's about. Do you want us to transcribe this type thing? So those should have been removed.
All right, so, is Terry in here, or,
Do you want me to go?
is she
Jason,
available?
go-
Yeah, right.
Sure. Back here.
Mr. John, just send a text. He would prefer not to mention that he's sick.
Okay.
That's an issue.
Hi.
We need to have the jury brought up. may be seated. Good morning, ladies and gentlemen of the jury. Sometimes in the course of a trial, evidentiary matters come up for the court to consider. The court has to have sufficient time to consider those. This is not the responsibility of either party here. It's the responsibility of the court to make sure things are addressed in the correct and timely manner. And there's a certain order of things that the court has to follow to make sure it's done correctly. So you've been brought here today, and the court is very appreciative of the fact that you're all here today in a timely manner. But the court is going to order a cancellation of this hearing today, so that we can deal with things in an appropriate order. So you'll be going home without hearing any evidence today. I'll give you the admonition here that you're waiting to hear in a moment. But the court wants you to understand that the court appreciates very much your presence, and it's very important that you do exactly as you've been doing, showing up each day and being attentive to what's going on. So with that, you'll be going home today without hearing evidence. You'll be back here Monday morning at 9 o'clock. You are not to discuss this case among yourselves or with anyone else. You're not to permit this case to be discussed with you or in your presence by anyone. You're not to form or express an opinion concerning the case until it's finally submitted to you for deliberation and verdict. You're not to do any research at all concerning the case, either as to the facts or as to the law from any source at all. And you're not to read, view, or listen to any reports or accounts of the case from any source at all. And that would include, of course, newspapers, radio, television, but also would include internet sites such as Facebook, other social networking sites, or any of the others. You're to refrain from all of that. And, of course, have no contact with participants in the trial, including parties, counsel, or witnesses. Again, the court appreciates very much your being here each day and your attentiveness each day. And does counsel for either side have anything you wish to add before I release the jury for the day? All right, you are released for the day with the instruction to be back here Monday morning at 9 o'clock. Please leave your notepads on your seats and wear your badges home and back tomorrow morning. Thank you very much.